video to discuss about the U.S. visa fee waiver. U.S. visa fee can range anywhere between $330 for diversity visa applicants to $535 for I-130 immigrant petition applicants applying for a relative. The work and tourist visa fee will also fall close to those numbers in hundreds of dollars. Usually, every visa applicant must pay the visa application processing fee for their respective visa category applied. Application fee is waived only on special circumstances, like what we are going to discuss in today's video. But before that, if you can hit the like button below, YouTube algorithm can recommend these videos to everyone interested in the US immigration topic. On January 20, 2021, the President Biden issued Presidential Proclamation 10,141 titled, "Ending Discriminatory Bans on Entry to the United States."
In the area of immigration. This is about how America is safer, stronger, more prosperous when we have a fair, orderly, and humane legal immigration system.
Based on this, State Department published a new rule in January 2022 by amending its regulations governing immigrant visa fees. This new rule provides one-time exemption for immigrant visa fee for eligible applicants. This rule took immediate effect, and it is already published in the Federal Register as final rule. What category of visas are qualified for this fee exemption? Is it applicable for future U.S. visa application, which is yet to be submitted? Will the fee exemption applicable for U.S. visa, which is pending with consulate for final decision? Will you get a refund if you have already paid the fee? To know more details about this rule and get answers to all your questions, please stick around till the end of the video. If you have not subscribed, please like this video and subscribe to US Immigration channel. Do not forget to hit the notification bell. Let's get into the video.
A few executive orders to strengthen immigration system, building on the executive actions I took on day one. I want to make it clear, there's a lot of talk with good reason about the number of executive orders that I have signed. I'm not making new law, I'm eliminating bad policy. What I'm doing is taking on the issues that 99% of them that the last president of the United States issued executive orders I thought were very counterproductive to our security, counterproductive to who we are as a country, particularly in the area of immigration. This is about how America is safe.
President Biden, earlier in Jan 2021, issued an Executive Order 10,141 titled, "Ending Discriminatory Bans on Entry to the United States." This executive order revoked Presidential Proclamations 9645 and 9983, which had suspended entry of certain nationals into the United States based on their visa type from certain countries. Even though President Biden's executive order reversed those travel bans, the applicants ended up paying the immigration visa fee to reapply for U.S. visa. In response to that, the State Department issued a final rule that exempts some immigrant visa applicants from paying visa application fees again. The rule, which was published in the Federal Register, applies specifically to immigrant visas that were denied under travel bans imposed by the Trump administration. Let's look into additional details regarding this fee exemption rule. Do not miss the frequently asked questions sections in the end of the video to know if this rule affects or benefits your family visa, tourist visa, diversity visa or work visa application. State Department's final rule allows individuals who were denied an immigrant visa between December 8, 2017 and January 19, 2020 to reapply for their visa without paying the application fee and any supporting fees if their application was denied due to Presidential Proclamations 9645 and 9983, which barred their entry to United States. Both the earlier discussed presidential proclamations imposed by Trump administration denied entry into the U.S. for many individuals traveling from various countries. These applicants will have their application fees waived only if a consular officer previously determined that their immigrant visa was denied solely because of Presidential Proclamations 9645 or 9983. Applicants whose immigrant visas were denied due to other reasons, while the entry bans were in effect, must still pay all applicable visa fees. Link for Department of State's immigrant visa fee is provided in the description. Let's look into some frequently asked questions regarding this rule. I already paid a second immigrant visa application fee. Can I get a refund based on this new regulation? This amended regulation took effect on January 19, 2022, and only applies to applicants who applied for their immigrant visa for the second time on or after the effective date of the new regulation. No refunds will be distributed based on this change to the regulations. My visa application was refused pursuant to Presidential Proclamation 9645 or 9983, but I was also refused on additional grounds. Am I still eligible for the fee exemption? Some applicants may have been initially denied immigrant visas under Presidential Proclamation 9645 or 9983, and also with additional refusal grounds. These applicants are not eligible for the fee exemption unless a consular officer had previously determined that the refusal on other grounds had been overcome and the immigrant visa has been not issued on January 20, 2021 due to Presidential Proclamation 9645 or 9983. My visa application was refused solely on Presidential Proclamation 9645 or 9983, but my visa application was refused after January 20, 2020. Am I still eligible for the fee exemption? Although this final rule does not apply to immigrant visa applicants who were refused on or after January 20, 2020, State Department regulations already provided options for the reconsideration of their previously filed application without an additional application fee. That regulation allows immigrant visa applicants to have their case reconsidered without payment of an additional fee by providing further evidence tending to overcome the ground of ineligibility on which the refusal was based within 1 year of the date of refusal. My DV 2020 application was refused pursuant to Presidential Proclamation 9645 or 9983. Am I exempted from paying a new fee? Generally, U.S. law requires diversity visa selectees to obtain a diversity visa before the end of the fiscal year for which they were selected, which will be September 30th of that year. For that reason, DV selectees from the 2017, 2018, and 2019 program years are not eligible to make a new application and cannot benefit from this rule. However, the Department of State is aware of a court order in Gomez v. Trump regarding the reservation and adjudication of DV 2020 diversity visas by September 30, 2022. A DV 2020 applicant who was refused solely under Presidential Proclamation 9645 or 9983 may benefit from the fee exception provision discussed here. DV applicants from the 2021 program year cannot benefit as they would have been refused after January 20, 2020. The fee exemption only applies to those refused on January 19, 2020 or earlier. Is the fee exemption rule applicable for tourist visa like B visa or work visa like H1B? This fee exemption rule is only for the family or other immigrant visa. Non-immigrant visas, such as those with temporary intent, like the tourist visa B1, B2, or work visa like H1B, L1 category, are not included in this rule. Thanks for watching this video. Hope the information presented is useful. U.S. Immigration Channel will be releasing more videos when additional information is available in any of these topics or regulations. If you have not subscribed, please like this video and subscribe.